Hear ye, hear ye, hear ye. The Court of Appeals for the 14th District of Texas is now in session. Pursuant to adjournment, God save the Constitution is on record.
Good afternoon and welcome to our oral argument this afternoon by Zoom. We have two cases on the docket. The first case is cause number 14-19-00989. It's a civil case. Sylvester Turner et al. Versus James Robert Jones et al. If counsel would make their appearances for the record.
Helen Petty for the city defendants, city appellants.
Thank you, Your Honor. It's Alan Waldrop on behalf of the appellees.
And then we will take a short break because we'll have a change of judges for our second argument. And our second case has two cause numbers, 1420-00231 CV and 1419-00967 CV. If the appellant would, Rahul K. Nath versus Baylor College of Medicine and Texas Children's Hospital, if counsel would make their appearances.
Yes, Melissa Lorber on behalf of appellant Dr. Rahul Nath.
Joy Soloway on behalf of appellees, Baylor College of Medicine and Texas Children's Hospital.
All right, we will put two of you in the waiting room, or three of you in the waiting room, and when that's done, we'll be ready for Ms. Petty to start. And you wanted to have 5 minutes for your rebuttal, is that correct?
I did, Your Honor.
We just find it less distracting if we put everybody in the waiting room.
Okay.
So Mr. Waldrop will go into the waiting room in just a second.
Your Honor, I'm arguing in the first case.
I know, but we're still putting you in. Well, you hear everything. We just black out your screen.
Got it.
Less distracting for everyone.
Got it.
All right. Ms. Petty, we are ready for you.
Thank you. May it please the court. There are two main reasons why the trial court was wrong to deny the city's plea to the jurisdiction. It mistakenly found a waiver of governmental immunity and it found standing. And I'd like to talk about both of those today. And I think that discussion will also resolve the appellee's petition for writ of mandamus. Starting first with governmental immunity, the appellees now admit that the case that they filed, the ultravirus claim that they filed, is not authorized. It requires a calculation of the dedicated street and dedicated drainage and street renewal fund contribution. I'll call it the DDSRF fund contribution in a manner not authorized by the charter and that doesn't take into account the charter's revenue caps. That's critical because section D of subsection D of section 22 in the provision that requires that contribution specifically references the revenue caps and leaves the ad valorem taxes subject to it, takes everything else out. So that's critical. So they now concede that the only way that they suggested that we should have calculated that contribution is both wrong, not authorized by the charter. Now, under Texas law, they're confined to their pleadings in a plea to the jurisdiction. And to the extent they have not demonstrated anything wrong with our not calculating it in an inappropriate way, that should have been enough for the trial court to have granted the plea to the jurisdiction. What they've done, instead of just conceding that, going back to square one or dropping their lawsuit, is to say, oh, no, we've come up with a new way, something that we think is better and gets us a little bit more money. And we have objected to that because it's inappropriate to raise it in the brief in the Court of Appeals when they didn't raise it below. But also,
well, I believe since the plea to the jurisdiction was denied, they can ask for the ability to replead.
They can, but what I want to talk about today is why that would be futile, because there is not a way that they can replead that would ever get them an appropriate ultravirus claim, for the simple reason that Article 3, which is the revenue cap, specifically authorizes and requires the city to calculate the revenue that's to be generated from the tax levy, which is the relevant the relevant language that is used both in Article 3 and in Article 9, Section 22, it requires that that be calculated in one of two ways, based either on a formula that increases the prior year by the consumer price index plus the rate of population growth, or by a straight 4.5% multiplier. That's how you calculate the revenue that's supposed to be generated for purposes of the revenue cap. And we argue that that specifically authorizes us to calculate the tax levy and the proceeds from the tax levy under Section 22 as well. Because it is specifically authorized that way, and we demonstrate, I think, in our brief that indexed approach is how we have calculated it, there can't be an ultra-virus act because the charter specifically sets forth the limits of our discretion, which include that kind of calculation. And I've walked the court through that at pages 14 through 17 of the of our reply brief, and our exhibits demonstrate how that calculation was incorporated into the budget for last year. So to the extent that it's specifically authorized, there is no way that they can ever replete. They may come up with 5 or 10 different other ways to calculate it, but there is no way that they can say for purposes of an ultra-virus case that we acted outside our authority, and in an ultra-virus context, they can't question how we exercised our authority within the limits imposed by the city charter. So we think that whether you dismiss it based on their pleadings, or whether you allow them to replead, they are never going to be able to say that the method that we used, that is illustrated by the exhibits, the jurisdictional evidence that we filed, that we acted outside our authority because we used the calculation that was specifically authorized by the city charter. With that in mind, and I think that gets rid of the ultra-virus case, with that in mind, because repleading would be futile, we probably shouldn't have to move to standing, but I'm going to talk about it anyway in case the court for some reason decides to send it back. And standing, they have a problem.
But we have to decide standing first.
Well, both are jurisdictional.
Ultra-virus, right?
Well, yes. Well, both are jurisdictional questions. And the court can do either one, but either one of them are going to deprive the court of jurisdiction. For standing, for them to have standing as taxpayers, they have not even purported to assert any kind of particularized injury. For them to have standing as taxpayers, they have to show things other than that they pay taxes. There's a very limited kind of relief that they can get. It's prospective injunctive relief that deals with expenditures. And they've not pleaded anything along those lines, because what they're talking about are allocations within the budget. They're not talking about expenditures. Consequently, they didn't plead any measurable added expenditures that you would need to for a taxpayer kind of claim. They didn't.
But they did ask for an injunction to stop underfunding.
No, well, they asked for an injunction asking for us to use a particular calculation, which they say leads to underfunding. So it's more of a mandatory injunction as opposed to one that prohibits us from underfunding. Because what the problem that we have is that there's no specification as to how much it's underfunded. They haven't given any specific amount. They haven't said it was spent on something that was inappropriate. They haven't said it was done by a separate tax, an added expenditure that added to the cost of some other activity. Consequently, they're never going to be able to meet those kind of taxpayer requirements. And that, we think, deprives them of standing. Their concern instead is with budgeting. Now, budgeting is not spending. Budgeting is simply putting it in a pile for later expenditure. And one of the problems they have in this case is that the expenditure or the allocation hadn't been made at the time that they filed their lawsuit. So they jumped the gun by a good bit. But their only concern is funding. Now, in this particular case, there's no requirement of minimum funding. And that, I think, goes to your question, just Christopher. There's nothing that says that we have to spend a certain amount on streets and roads in a given year. This simply puts money in a pot for those expenditures at whatever point they're made. Second, there's nothing about Section 22 that says that you can't spend other money that the city has for streets and drainage purposes. And in fact, that's exactly what we did before this amendment was put into place in 2011. Third, money would be allocated for streets and drainage in the absence of charter amendment and was in the past. So they're never going to be able to show the kind of taxpayer standing that they would need to get them to the place where they would be able to stand up a claim against the city or anyone else. In addition, go ahead.
I'm sorry, who would have taxpayer standing if the city was failing to fund the drainage fund in accordance with the vote of the people? Who would have standing?
Your Honor, I don't know. I mean, there's whoever would have a particularized injury. I think you could start, but with regard to taxpayers, I think there's a difference between if we weren't funding it at all, which are some of the cases that the appellees have cited, or if we were simply not funding it to particular levels. But I would go back to the discussion that we had with regard to governmental immunity. If we are operating within our discretion, just because we're funding it at a level that is less than Mr. Watson or Mr. Jones or any other taxpayer would suggest, that is not something that is cognizable as a claim by a taxpayer or as an ultra-virus claim. Instead, they would have to show that we're acting outside our authority, but as I've demonstrated, I think we're acting specifically in line with Article 3 and the kinds of calculations that Article 3 requires. In fact, I think if you flip it over, you can see that better. If this court were to hold that it was an ultra-virus act to calculate the revenue from the ad valorem tax levy in a manner that fits right within Article 3, that is required by Article 3, you would put the city in an impossible position. It would be calculating its revenue for purposes of the revenue cap in one way, and it would be prohibited from calculating really the same amount for purposes of the DDSRF contribution. And I'm not sure how the city could ever resolve that.
Okay, thank you. You'll have time for rebuttal.
Thank you.
And now we will hear from Mr. Waldron.
There we go. Can you all see me all right?
Yes, thank you.
Thank you. May it please the court. I'm going to start with just responding to the host of misleading comments that were made about what we're conceding and what we're admitting. We are conceding and admitting none of the things that you were just told we are conceding and admitting. So for example, you
do seem to have changed your theory here on appeal versus in the trial court.
Actually, Your Honor, that's one of the things I was going to say is just flat not so. We have not changed our theory top, side, nor bottom. Our theory was that it was not the correct amount at 11.8 cents per $100 of value has not been funded to the drainage fund. I'm just going to call it the drainage fund for the purposes of this argument. That has always been our theory from the word go. What we have changed in the briefing that we did in our original petition and what we have done to this before this court is simply readjusted the way the equation is run, because as through the jurisdictional argument in the trial court, we received on the day of the hearing the budget, and the budgetary information was put into evidence, and we took the city's we took the city's own numbers and plugged them into the math. The theory has not changed at all. The math can be arrived at in two very distinct ways, and let me describe those to the court. One way is to, since what the charter provides without question is that 11 cents out of every $100 evaluation of whatever the tax levy is has to be funded to the drainage fund. You can get there two different ways. You can go to the total valuation of property that's ultimately decided for any fiscal year. You can then apply the 0.118 for every $100 of valuation to that number, and you can derive the starting amount for the funding of the drainage fund. Another, which is the calculation that we put into our original petition. Another way, mathematically, you can get to the same number is by going to the city's numbers itself, using the actual tax levy amount that the city is working with out of its budget, which we did and pulled it out for the purposes of the briefing here. And you can run the math on it, which is exactly the same math, just done in a different formula. But the math is the same and the same exact figure is derived.
But you do agree that the statute ordinance requires the actual tax levy, not the total value.
Absolutely. Well, that's right. But the way you get to the tax levy is you have to start with the total valuation and apply a rate to it, the rate that ultimately the city decides it's going to apply. And this is why I say, for example, and we have said repeatedly, the revenue cap has nothing to do with our theory in this case or what the issue in the case, because the revenue cap applies as the city is going to through the process of figuring out what the tax levy is going to ultimately be. Once they work through that process, applying the cap, applying all of the other requirements that they have to apply as a matter of state law to deriving a legal tax levy, then whatever that tax levy is, whatever the amount of it is for any given year, the charter provision provides that an amount equivalent to the proceeds from 0.118 per tax for $100 of taxable value, the city's ad valorem tax levy minus an amount equivalent to debt service has to be set aside. It absolutely requires.
But my understanding is that the city sets its budget before it knows what the actual tax levy will be. Do you agree with that?
It sets it, but not exactly. It sets its budget before it knows what the final numbers are going to be. I do agree with that.
Okay.
Now,
and so they make an estimate at that time and apply the 0.118 percentage, correct?
Correct. But they don't apply, but they didn't apply the 118%, and that's our complaint. You can look at the proof. Our complaint is this, and we have alleged it this way. You can look at the budget and you can tell that they have not applied the 0.118. They've applied something else. And this is an important point for the court to know. The city keeps saying, oh, we've demonstrated we're doing this right. The city has provided zero calculation in this case of how they got to what they're going to put into the fund, which is only $47 million. They have provided no calculation. There is no way to know how they've done it. They're just saying we did it right.
So if there is no way to calculate it, how, what's the ultra virus claim here?
No, I didn't say there's no way to calculate it. What I'm saying, Your Honor, is the city has not done that. What we are saying is you can take the budget numbers of what the city has said it is going to do. It has said if we have a tax levy of X, we apply a tax levy of Y, here's what we're going to put into the fund. If you run that calculation, it is short almost $50 million from what it ought to be if you actually ran the calculation using their numbers with 0.118. What we can know.
But you're using the numbers that come out later, not the projection that happened at the time of the budget, correct?
No, ma'am. The only numbers that we have right now are the numbers from the budget. If, for example, and they're going to always be pretty close at the end of the day, but if, for example, the tax levy came out a little bit different in the actual tax levy from what it is in the budget, our position does not change. Whatever the actual tax levy is in fact the tax levy that has to be used for purposes of the charter provision, and then the 118 needs to be applied to it. Whatever the actual tax levy is, that's our position. Now then, the reason that we point to the budget is evidence. The budget is evidence that the city is currently not following the formula that the city charter requires. You can take the city's numbers that they put in their budget. You can run the numbers just mathematically according to either one of the calculations we've provided to the court in the record, and you can know that the city is underfunding what they're supposed to be funding by almost 50 million. You can know that by running the math, and we've done that, and that's our allegation. Here's an interesting thing too. The city itself has admitted as much, and this evidence is in the record. The city issued a press release after we filed our lawsuit. In that press release, the mayor's office admitted that transferring the 11.8 cent full amount would mean a reduction to the general fund budget of 50 million in this fiscal year alone. That would mean cuts to essential services like police, fire, solid waste, and other services. Mayor Turner does not support that. They go on to explain that the 11.8 cent amount has to be adjusted. No, it doesn't. There is no provision in the city charter at all that 11.8 cent amount can be adjusted, and that's our point in our lawsuit. We are alleging the city officials have no discretion and no authority to do anything other than fund 11.8 cents for every $100 of valuation from the actual tax levy, whatever that turns out to be. And what we know right now is they are not going to do that to the tune of about 50 million, which frankly will cripple the drainage fund in very short order.
Can you explain how you have standing to bring the lawsuit?
Yes, Your Honor. It's very straightforward on standing. We have standing under the Bland case because we are taxpayers, and this involves the illegal expenditure of tax revenues. As explained by Justice Pemberton in the Hindi case, and in other cases where, as the first court, also the sister court there in Houston said in Turner versus Robinson, the illegal expenditure of tax revenues includes failing to fund something that has to be funded with tax revenues and sending those funds, those tax revenues elsewhere. The expenditure of tax revenues somewhere other than where they are required by law to be spent is an illegal expenditure. Turner versus Robinson, the first Court of Appeals, noted that they noted in that case that under this very ordinance, one of the ordinances for the city of Houston involving the cap, if the city took revenues over and above the cap, those revenues are illegal regardless of where they sent them. And so they recognized that the plaintiffs in that case had standing. We have standing for the same reason. We have alleged that the city expending tax dollars, the $50 million in tax dollars that it's supposed to be funding to the drainage fund, spending that $50 million somewhere else is an illegal expenditure because it violates the city charter. That's why.
But in Turner versus Robinson, they were actually taking more money from the taxpayers versus taking one pot of money and putting it in two different places.
That's correct.
That's a big difference for taxpayer standing.
Well,
and the Supreme Court case of Andrade says you have to show that they actually spent money on an illegal activity. And in Turner versus Robinson, it was illegal because they were taking too much money from taxpayers. But in this case, they're not taking too much money from the taxpayers. They're just putting money in different pots.
Well, no, you're wrong. Well, that's true. They are putting money in different pots. And our point here is they have no discretion as a matter of the charter to put the money that is supposed to go in the drainage fund into another pot. There's no discretion about that. That is illegal. And if they take tax dollars that are supposed to be in the drainage fund, and they are, and spend them elsewhere, those expenditures are illegal. And frankly, Your Honor, I don't believe that Andrade is inconsistent with that point. That if you take tax dollars that are supposed to be expended in one way and you expend them in some other way, that expenditure is illegal, and that gives us standing to challenge this. Now, I will say on this point of standing, Your Honor, as a procedural matter, standing was not raised in the trial court, and so consequently, we didn't have to meet that objection in the trial court.
Well, it actually was in the plea to the jurisdiction. It mentioned standing. I would agree with you that it wasn't fleshed out very well, but it did mention it in the plea.
It mentions it by basically conceding that we have standing. It says if you look at the language that's in the plea to the jurisdiction, it is basically conceding we have standing and not raising a point about it. Now then, what I would say about that procedurally, if this court has, I think that prevailing law, we think that prevailing law is very clear that we have standing under these circumstances where there is a complete failure to follow the law. Now then, but if this court has any concern about that, then the correct option is to give us an opportunity to go back and replead, because we've never had that opportunity.
But how would you replead? You don't have a particularized injury.
Well, we're not alleging a particularized injury, Your Honor.
Right.
We are alleging the exception to that rule that requires particularized injury that is well recognized by the Supreme Court in numerous cases and other courts as well, that you don't have to have a particularized injury if you're a taxpayer and you are challenging illegal expenditures. That's what we're relying on.
Right, but these expenditures are not illegal. They're just they're being spent on legal things that the city's allowed to spend money on.
Well, no one knows that here. And there's two things about that. Number one, that's not proven. And so if the court says in its opinion that, oh, but these expenditures are all legally made, I would suggest the court doesn't have a record to make that statement. But more importantly, they are not legally made. There has to be, as a matter of logic, there has to be a way of saying when a government entity that is required to make certain expenditures in a certain way does not make those expenditures, as the court asked Ms. Petty, who would have standing? Well, we have to have standing in order to enforce whatever law that requires those expenditures to be made correctly. So what we know is this $15 million is not being expended correctly. We know that. We don't know where it's going. We just know that it is not going where it ought to go, and that's illegal. I see that my time's expired. I'm happy to take any other questions the court might have.
Thank you. All right, we'll hear from Ms. Petty on rebuttal.
May it please the court. One of the reasons why standing in this context is so important is because it prevents cases like this one from coming to court. And that is where you have plaintiffs who decide that they know better than the city, and they're going to have a DIY or a DIY type calculation that the city should use, and city should listen to them and go forward. That's a political concern. It's not a legal one. What is at issue here, though, is the question that Mr. Waldrop never answered. And that is, how is it possible that the charter specifically authorizes the calculation of the revenue from the ad valorem tax levy to be calculated in two alternative ways? And the city is using one of those, as is demonstrated by the evidence that he seriously misrepresents. How can the city be operating outside of its authority when it's doing that, when Section 22 specifically references the revenue cap? Now, you will note that
Ms. Petty, he takes the tax levy, the actual tax levy, which you argue that he should, and multiplies it by 11.8 cents. How is your calculation different?
calculation is an indexed calculation, just as the revenue cap is an indexed calculation. As we explain, I think it's 14 through 17 in our reply brief, what the city has done is use 2012 as a base year. For the revenue cap, they use 2005 because that's the year it came into existence. 2012 is the year that Section 22 clicked in. And then that number has been indexed up each year under the calculations used for the revenue cap. And this number is that indexed number. The reason that you need to use it that way is because that's what we use for the revenue cap. What Mr. Waldrop and his clients would have us do is to have an artificially indexed number, which is the revenue cap, control what the city brings in terms of its actual revenue, and have a number that is based on valuations, because he hasn't quite represented his calculation correctly to the court. It's based on tax valuations again. And so what you would end up with then are two numbers that are out of sync. And you would end up with one number that is larger than the other, and that we have to take 11.8 cents of that, even though our revenue is indexed. And so that's the reason that we've used a parallel type of calculation, which again is specifically authorized. What the appellees in this case would require, however, and again, it's not in their pleadings, I guess it would be in their updated pleadings, is a means of calculating the tax levy and the proceeds from it that isn't found anywhere in the charter. Section 22 does not give a specific means of calculation. Instead, it references the rev cap calculation. And so that is what we've done. Now, the idea that somehow we have to set all that out for the taxpayers is not correct. We've done that. Our budget reflects the number, and I've indicated to the court how that was calculated in our brief at 14 through 17, and the court can see that. This may be a perfectly fine calculation, but again, the issue for Ultravire is are we operating outside of our authority, our discretion? And the question is that we are not. What he is asking this court to do is allow he and his clients to dictate how we operate within our designated discretion. And that's not an Ultravire's case. Now, I want to, in the few seconds I have left, talk a little bit about standing. He has completely misrepresented the law. I'm the lawyer in Turner versus Robinson, now Turner versus Hotze, and it says nothing of the sort. Nothing about any of those cases says that you don't have to have some sort of expenditure. Turner versus Hotze was about, do we enforce two competing revenue caps? In addition, he ignores the contrary authority in the Perez case that we have cited, but those cases don't help him at all. Instead, what he had to show was specific expenditures, and he's basically said, oh, no, I don't. They must be spending it illegally somehow. There's no allegation in his pleadings, nor would there be, of any sort of illegal expenditure. He would have to suggest that we are somehow spending it on something that is outside of anything else. But given that ad valorem taxes are part of our general fund, they could be spent on almost any city product. So that's kind of, speculation and guesswork on his part, but that doesn't anywhere meet his obligation, his requirement to show specific expenditures, to show, expenditures on things that would not be bought ordinarily. And he's not even purported to do any of those things. And for both the reason for standing and on waiver of immunity, the court was wrong below in not granting the plea, and we'd ask the court to rectify that error. There are no more questions. I thank the court.
Thank you for your argument in this case, and it is submitted. Thank you, Mr. Waldrop, and you all will be excused.
Thank you very
Thank
much.
you.
All right, see you later.
Sudafed time.
Did our participants get booted out also?
What?
Our litigants. I don't see them on anymore.
I guess they're in the waiting room.
Hello.
Good afternoon. Thank you for joining us.
Thank you for having me.
We are still live.
All right, Judge Wise, I'm going to go ahead and bring the last two attorneys in.
Okay.
And of course, we're not going to hear you again. It'll just be a few to start it.
What you got?
Hello again.
Good afternoon.
Hello.
All right, this is Nath versus Baylor College of Medicine and Texas Children's Hospital. Panel member change. Appellant, would you like to reserve time for rebuttal?
Yes, Your Honor, 5 minutes, please.
Very good. All right, you may proceed.
May it please the court. In my opening 10 minutes with the court, I would like to address two issues. Why this case presents a different question than this court decided in Patel versus Patel, and why Rormus and other Texas Supreme Court precedent direct that if this case did reach trial, a jury should have determined the amount of reasonable fees, if any, that should be shifted to Dr. Nath. In this case, there is no dispute that the sanctions against Dr. Nath were based in large part on him speaking out about Dr. Schnack operating while suffering from hepatitis and blindness. The Supreme Court says that much in Nath 1. That's an issue that would be protected under the TCPA. The two questions remaining then about the TCPA are whether the hospital and Baylor's motions to reassess the sanction brought in 2019 are a legal action susceptible under the definition of the TCPA. And if so, in response to Dr. Nath's motion, did the hospital and Baylor properly come forth with prima facie evidence to support their sanctions requests? This case presents a different question than this court looked at in Patel, and a different question than the Dallas court looked at in Barnes versus Kinzer. In both of those cases, the plaintiffs filed a lawsuit and the defendant, fairly early in the case, filed a counterclaim for sanctions seeking dismissal of the plaintiff's claim and sanctions. In that situation, this court held that the defendant was trying to timely and inexpensively get rid of meritless claims and to hold that allowing the plaintiff to file a TCPA motion in response to that would be contrary to the purpose of the TCPA, which is quick and inexpensive resolution of meritless claims.
So the claims at issue here, they before the TCPA was even first enacted. Is that correct?
The claims in this case?
That's the claims that are being complained of in the current TCPA claim.
Well, so originally the Baylor and the hospital filed their motions for sanctions in 2010 before the TCPA, but their motion for sanctions have been twice, the sanctions awards on those motions have twice been reversed by the Supreme Court. And each time they've come back on remand, they filed new motions seeking to change the reversal, seeking new relief, seeking the sanctions to be assessed again. And so it's in 2019 when they filed that renewed motion for sanctions, however you want to call it. They get angry with me for calling it that, but whatever it was in 2019, they sought to go from a zero sanction, no sanction had been affirmed, to some amount of sanction. And at that time, they filed a legal action. And the reason this is different than the Patel case is far from seeking early in this case to quickly and inexpensively do away with meritless claims. Baylor and the hospital waited for 4 years of litigation until after they had received a final judgment and the lawsuit was over. And that's the first time they sought sanctions. And they didn't seek sanctions in dismissing claims. They sought case-long sanctions, fee-shifting sanctions against Dr. Nath. And from that day, post-judgment, when they sought sanctions, that's been the only legal or equitable relief request that's been keeping this case alive. And it's been what's been keeping it alive for 10 years. This case was over, but for their request for legal or equitable relief. That falls within the broad definition of a legal action under the TCPA and presents a different question than Patel. So we ask for this court to hold, consistently with that language in 27.0016, that this case, those motions are legal actions.
So just to get this absolutely clear, for the most recent set of motion practice was Dr. Nath filing a TCPA motion against the sanctions.
Yes. So in
is that correct?
Yes, they filed they filed what they called motions to reassess the fees, reassess the sanction. Right. And so Dr. Nath filed a motion to dismiss their new 2019 pleadings. Okay. Yes. Oh, good. And so once Dr. Nath filed his motion to dismiss, the Baylor and the hospital were required to come forward with a prima facie case to support their claim for sanctions. They came forward with voluminous documents, but all of which were pleadings, orders, and court opinions, no sworn evidence whatsoever. They did point back and ask the court to take judicial notice of the file. And in the file, the only thing in the file that had not been reversed by the Texas Supreme Court was their new 2019 fee. One was a declaration, one was an affidavit, but all they did is proved up what they opined were reasonable and necessary fees. Neither of them addressed at all what the Supreme Court remanded this case for back in Nath 1, and which the Supreme Court said in Nath 2, their conclusory affidavits were insufficient evidence. And that is the degree to which they caused any of the fees that they sought to shift to Dr. Nath. They failed to come forward with that evidence at all. And if that wasn't an essential element of their claim, the Supreme Court would not have remanded for that in Nath 1 and again in Nath 2. So we ask this court, in response to the TCPA motion, to dismiss the sanctions claims. Secondarily, we ask the court to decide this appeal in two parts and to decide the interlocutory motion to dismiss first. But if the court reaches the second half of this appeal, and if the trial court properly reached a trial on the merits of this sanction at all, it should have gone to a jury. The reason for that is Ramos and Nath 2 changed the law about how fee-shifting awards should be handled in sanctions cases. The hospital and Baylor acknowledged that they changed the law. After Ramos said that all cases now where you seek to shift fees to the other side, you must prove reasonableness, and they set out the factors you must prove. In Nath 2, the court made clear, we mean that, all cases, including the sanctions case. Ramos, of course, had a jury decide that issue, and Ramos and numerous other Texas Supreme Court cases have held that in virtually every case, a jury should decide that issue. So after Ramos and Nath changed the law on this and said sanctions, fee-shifting sanctions, when you're starting from day one and saying, I want to shift all my fees, that's going to be handled in a sanctioned case just like any other case, which requires a jury. The hospital and Baylor have been arguing that a decision decided in 1984, Brantley versus Etter, prohibits Ramos from changing the law on this. And it doesn't. In fact, it presents a very different situation. In Brantley versus Etter, it was a former Rule 215 case about not responding to discovery, specifically in that case, failing to appear for a deposition. So it was a discovery sanction. And what the sanction was being awarded and being sought was, you didn't appear for the deposition. What should be the punishment? What should be the amount you should have to pay because they showed up and you didn't? And the court assessed that, and the Supreme Court said in 1984, it's okay. The court had authority to do that. This case is very different. This case is not saying you did one thing on one day, it was wrong. It's saying after 4 years of litigation, everything in this case is wrong, and we want to shift all of it to you. And so we want to go back and we want to go to day one and we want to shift fees. It presents the same situation as Rormus. and a jury should decide that question. Indeed, since Wormuth and Nath, the Corpus Christi Court of Appeals decided the Pisharati, sorry if I'm saying that incorrectly, case, which is about fee shifting under the TCPA. And the court recognized, as I've been discussing today, that in virtually every case, you need to have a jury. And it concluded you need to have one with TCPA fee shifting. And it specifically is very good analysis that the court should look at, because it's based on 3 Supreme Court decisions. And they say what you need to look at here is, what does the language of the underlying statute say? The underlying statute that is the basis for a fee award, who does it say should decide the amount of reasonable fees? And if it's a tie, if it's unclear, the default goes to the jury. Unless something about the particular statute says the court must decide this, then the jury gets to decide it. And if you look at the language in this case, the Supreme Court held in Nath 2 that the sanctions in this case were under Chapter 10 of the Civil Practice and Remedies Code. And if you look at the language in this statutes, it is very similar. It doesn't say that the court gets to decide reasonableness. It says if the court determines there should be a sanction, a court can impose a sanction. Then it lists the things that the sanction can include, one of which is attorney's fees. And it's very similar to the language discussed in the Corpus Christi Court's decision that the Supreme Court in Crump, City of Garland, and Boquette said that language means you get to jury. And that's the language we're dealing with today. And so we ask that Dr. Nath's request for a jury be given credence, and that if this case isn't going to be dismissed under the TCPA, that it be sent back for him to have this issue decided by a jury.
All right, thank you very much. We're going to switch videos, hear from the appellee.
May it please the court, Joyce Holloway for both appellees. I'd like to first address the threshold issue of the TCPA's applicability. As has been mentioned, we had 2 arguments in the trial court and 2 arguments in this court as to why the TCPA is inapplicable. Our first argument was, this has been pointed out by Justice Hassan, was that our motion for sanctions were filed back in 2010. To be clear, I do not get angry at Ms. Lorber for arguments that she has made in this case, but we do disagree very strongly when the appellant says that our motion for sanctions was filed in November of 2019. That is just not the case. The operative pleadings were filed in 2010. The TCPA was not enacted for another several months. It went into effect in June of 2011. It has no retroactive effect. So when you consider what our operative pleading is, which are the 2010 motion for sanctions, the TCPA just simply does not apply. Now, if we were to indulge the appellant's argument in this case that the operative filing is our 2019 filings, which were not motions to reassess, but they were fee applications consistent with the remand following Nath 2, there's a second reason that the TCPA is inapplicable, and that is because of this court's decision in Patel versus Patel. Now, last Thursday, when the appellant filed their reply brief, they acknowledged that Patel versus Patel was dispositive of this issue, that Patel versus Patel held that a motion for sanctions is not a legal action within the meaning of the TCPA. They seem to have a different position today and is set forth in their letter brief yesterday afternoon, but we would submit that Patel versus Patel is dispositive. Now, it's not distinguishable. It's not distinguishable on the basis of when the motion was filed. I totally agree that the purpose of the TCPA was to allow for an early exit by a defendant from a case. But Mr. Nath didn't file a TCPA motion early in this case to exit a claim that he thought was baseless. Remember, Mr. Nath was the plaintiff. And then 9 years after this case was pending, Dr. Nath, I don't mean to be disrespectful, he filed his TCPA motion. So there was no way that this case could be decided early under the TCPA. Again, in his reply brief, Dr. Nath agreed that Patel was binding and acknowledged that in order for this court to revisit Patel, that there needed to be either en banc review or that the court should just reaffirm Patel and then Dr. Nath would take it up with the Texas Supreme Court.
So same question to you that I had for Ms. Lorber. The procedural posture of the case is that after this case was remanded back to the trial court after Nath 2, what was still left? What did the Supreme Court leave alive?
Well, our position, and I think this is very straightforward from Nath 2, is that in April of 2019, the Texas Supreme Court had changed the standards for how you're going to prove attorney's fees in the state of Texas. And then in Nath, in June of 2019, it extended that rule to sanctions shifting cases. And so for that reason, the Texas Supreme Court said, look, we've changed the law. We acknowledge we changed the law as to fee shifting in sanctions cases. So we need to remand it to the trial court so that the appellees, the defendants, have a chance to resubmit their attorney's fees in compliance with the new standards. And that's precisely what we did.
Your position, just so that I'm 100% clear, is that the sanctions application that you made after Nath 2 was a continuation of the original sanctions and attorney's fees that you sought in 2010?
Precisely, Your Honor. In 2010, Judge Kirkland had issued extensive findings of fact and conclusions of law, finding that Dr. Nath's filings were frivolous, filed in bad faith, and for an improper purpose. This court affirmed, the Texas Supreme Court agreed that Dr. Nath should be personally sanctioned for his bad faith conduct. The first time the Texas Supreme Court remanded it was only because Judge Kirkland had not considered what we call low factor N, and that is whether Baylor and Texas Children's were at all responsible for any portion of the fees that they incurred. So after the first remand, that low factor N was litigated, and that went up to the Texas Supreme Court. And then they said, well, we've changed the law in rumors, and now we've got to send it back down. So then we submitted our attorney's fees, we proved them up in accordance with these new standards. We went ahead and we provided opposing counsel with our invoices. We had an evidentiary hearing, and then the Judge Palmer, who succeeded to Judge Kirkland, she went ahead and she entered findings of fact and conclusions of law. I will say there was some question in Nath 2 whether the issue of low factor N needed to be relitigated. We thought the Texas Supreme Court was somewhat ambiguous in that. We went ahead, just as a precautionary matter, to go ahead and put on substantial evidence as to why nothing that we had done contributed to our incurring these attorney's fees. And I would refer the court to Ms. Clark and Mr. Meisel's painstaking analysis of everything that was required from the day that Dr. Nath filed his original petition until the day that he actually withdrew all his claims in his Fifth Amendment by filing his Sixth Amendment, and then filed recusals and so forth. I think Judge Wise probably has some of this procedural history memorized, as the rest of us do, just because he authored the opinion in 2016 from this court. But so that's the small part of this case that was left after Nath 2.
Thank you.
So it's our position that the TCPA is inapplicable. We also provided the trial court and this court other bases on which this court can affirm the trial court's denial of our TCPA motion. One of those bases was that a post-remand TCPA motion was unauthorized by the Texas Supreme Court's decision in Nath 2 and in their mandate. And we refer the court to the Johnson-Todd case out of the Beaumont Court of Appeals, which is very similar to the posture of our case. And we would respectfully submit that there is no daylight between that court's holding and what we're asking this court to agree with about the trial court's decision, that any other issues were outside the scope of the remand. We had many other bases on which this court can affirm the trial court's decision on the TCPA issue. So I'd like, in my remaining time, unless the court has any questions on the TCPA, to move to the second portion of Nath's appeal. The first issue that Dr. Nath raises is that he had a right to a jury trial. I want to make a point based on the record in this case. When you look at Dr. Nath's jury demand, he acknowledges that under existing law, he is not entitled to have a jury try this case, try the issue of the amount of fees. He filed that demand on November 6, 2019. There has not been any change of law. Dr. Nath said that maybe Brantley was distinguishable because in his case, there was an injunction at issue. He's abandoned that argument in this court. So we would submit that the 1984 decision in Brantley is dispositive. This is not a case of first impression. When Dr. Nath filed his jury demand, we filed a motion to strike. And in that motion to strike, which is at 4 SCR 1035, we identified 3 cases that have recently held consistent with Brantley that sanctions motions are to be decided by a court and not by a jury. One was a Chapter 10 case and one was a Rule 13 case. Those are the Miller versus Bank One cases and the Neely case. I think the Neely case was out of the First Court of Appeals. There have been other cases that have held outside the sanctions context that in fee-shifting situations, such as under the TCPA, the Pershaty case, that a litigant is entitled to a jury trial. But I am not aware of any case since Brantley that has ruled that a sanctions issue is to be tried by a jury. And I do not believe that Dr. Nath has identified a single one. And it is true, as Ms. Lorber said, that in Nath and Wormos, the Texas Supreme Court did change the law as to the type of evidence that is required to prove up fees in all cases. But neither of those cases said a word about jury trials. And in fact, in Nath 2, the Texas Supreme Court cited Brantley for the proposition that in sanctions cases, you do not get a jury trial. I will agree that the Brantley case was a discovery abuse case and not a pleadings abuse case, but that's a distinction without a difference. And Ms. Lorber hasn't explained why there would be a difference. We don't want trials within trials, that when people abuse the process, that they should then get to even make the fees even more deep by having a jury trial and prolonging the proceeding. So we would submit that consistent with Brantley, the Miller versus Bank One case and the Neely case, that this court confirm that Dr. Nath was not entitled to a jury trial. On the issue of the evidence that we put on at the hearing, we would submit that we put on substantial evidence as to why our fees were necessary and reasonable. We had affidavits, we had the invoices themselves, we had hours of testimony, and there has been an issue that has been raised in the pleadings that since the Texas Supreme Court had held that this case was from the outset frivolous and should have been dismissed, how could we have incurred so much in fees? Well, the answer to that was provided by none other than Mr. Nath's own expert, Mr. Crouch, who testified that when you look at Dr. Nath's original petition, you cannot tell that it's facially implausible. He doesn't, in his first petition, his original petition, he did not identify who made the alleged defamatory statements. He did not state when those statements were allegedly made. So yes, we eventually were able to prevail on limitations, but we could not have done so at the outset. Mr. Mizell, lead counsel for Texas Children's, and Ms. Clark, lead counsel for Baylor, explained that Dr. Nath had also pled the discovery rule and the self-publication rule, which are ways to toll limitations in defamation cases. So for that reason, an earlier motion for summary judgment would not have worked. And then, of course, when we did file a motion for summary judgment, after Dr. Nath finally specified the factual basis for his claims, he moved for a continuance and was granted one. And he filed then a very robust response to the motion for summary judgment, which Mr. Mizell discusses in his testimony. So we would respectfully submit to the court that we provided the trial court with ample evidence in support of her findings. I'd like to conclude by discussing briefly the standard of review that applies to the issues that Dr. Nath has raised. On the issue of applicability of the TCPA, that is, of course, a pure legal issue, which we submit this court has already decided. On most of the other issues, the standard of review is abuse of discretion. Whether the trial court erred in excluding evidence, as Dr. Nath has complained in his brief, that is reviewed for an abuse of discretion. Whether he was entitled to a jury trial and was wrongfully denied that jury trial, if not disposed of by Brantley, is also reviewed for abuse of discretion. And of course, whether the award that was made by the trial court is that's determined by whether there is legally sufficient evidence. And that means, well, is there some evidence in this record? And we would submit that there is substantial evidence in this record supporting all the fees that we have submitted. So in conclusion, we would ask that the court affirm both the denial of the TCPA motion to dismiss and also affirm the sanctions award and the findings of fact and conclusions of law. I thank the court very much.
Thank you, counsel. We'll now have rebuttal. Ms. Lorber.
I'm back. Thank you, Your Honor. A lot of what Ms. Soloway just gave the court is the argument the hospital in Baylor should have made to a jury. She wants to say that because Dr. Nath's trial counsel wrote that he wasn't sure if the law was clear that he should have gotten a jury or not is somehow determinative. But what matters is whether the Texas Supreme Court and this court, as a legal matter, determined that a jury should have been required. And no one disputes in this case that Wormuth changed the law. Wormuth said sanctions cases are handled just like all other sanctions cases that fee shift are handled just like all other fee shifting. In those cases, get a jury. So there should have been a jury here, and that's a legal question, not something that is up to the interpretation of one of the counsel in this case. It's for this court to decide as a post-Wormuth matter of first impression. Wormuth also reminds us of a second important thing. Just because a party and its attorneys make an agreement to pay fees, if they want to pay millions of dollars to litigate a case, they can do that, but it doesn't make the fee reasonable. A jury needs to decide whether that fee is reasonable. And it's hard to believe that a jury would decide that on the facts of this case. But if the hospital in Baylor want to keep pursuing this massive sanction against Dr. Nath, we need to put that question to a jury. This court, Dr. Nath did argue in his reply brief that we believe Patel versus Patel was inconsistent with the language of the TCPA. We're arguing further that in addition, the reasoning for saying we're not going to follow the strict broad language of the TCPA is because of the purpose of the TCPA is different in this case than in Patel. So I think the court, in addition to reconsidering Patel, can also say that this case does not present the same public policy issues and the same reason from departing from the language, the definition of legal action. Also, Johnson-Todd is very different than this case. They say it's determinative on whether a TCP motion could even be heard, and it's not. The instructions in that case were trial court, you need to dismiss claims and you need to award costs. That's not what happened here. What happened here in NAF 2 is the Supreme Court said very clearly the hospital in Baylor tried to cure the problems from NAF 1 with conclusory affidavits. They are not enough. So the issue from NAF 1, whether they caused or contributed to their fees, was still alive. And also, they didn't prove their attorney's fees the way they need to under Vormuz. Both of those issues are still alive.
But so, again, do you then agree with your opposing counsel that this was a continuing motion for sanctions that had been alive since 2010?
They're building off of each other. They were alive, it was overturned. It was alive, it was overturned. It was alive. But they themselves took the affirmative action each time they were reversed to bring it back and ask for it again and to ask for it in a different way. And in fact, the hospital asked for more this third time around than they had asked to the first or second by asking for appellate attorney's fees. Last week, the Texas Supreme Court granted review in another sanctions case out of this court, which is Landry versus Animal League Defense Fund. And some of the counsel for Landry's in that case are the same as some of the counsel for the hospital and Baylor in this case. So they're in opposite positions in that one. And one of the things they argue in that case is that the $175,000 sanction, just a tenth of the amount they're asking for here, sticks out like a sore thumb because it's unusually high, particularly when there's no evidence that Landry's was in need of deterrence in the first place. They're triggering the due process requirements that underlie a sanction. And it's true, the Texas Supreme Court does not like massive sanctions, which has been demonstrated by the fact that they have already twice reversed the same sanction that the hospital and Baylor are seeking for a third time in this case. That sanction simply cannot stand until due process requirements from NAF 1 have been met. Dr. Nath's constitutional right to have a jury decide disputed fact issues, including attorney's fees, is met. And his TCPA motion is dealt with, including on an interlocutory appeal, which he had a right to under that statute. So Dr. Nath asks, instead of us having to go to the Supreme Court again, to please carefully consider this case. Please either reverse and render judgment for Dr. Nath under the TCPA, or abate the second half of the appeal. Let us take that one issue up to the Supreme Court, including the conflict between the courts of appeals. Or alternatively, if the court reaches the second half of this appeal, please remand with express instructions that a jury trial is required. Thank you very much.
Okay, thank you very much, counsel, for your arguments. Nath versus Baylor College of Medicine and Texas Children's Hospital is submitted, and